Glad everybody could be here on such a lovely day. Dudley Miles, could you lead us in prayer, please?
I'll be happy to do you pray with us. Lord, we're grateful for your presence in our lives. We thank you for this nation. We thank you for this region. We thank you for the state, for the city, and those that serve, that we might enjoy the freedom we enjoy every single day. We thank you, Lord, and are mindful of the needs of others. Now bless us through our body and us to your service, which in your name we pray. Amen.
Anthony Draper, could you lead us in the pledge?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And John Barry, could you lead us in the four-way test, please?
Four-way test of the things we think, say, or do. First,
Is it the truth? Second, is it fair to all concerned? Third, will it build goodwill and better friendships? Fourth, will it be beneficial to all concerned? No promises, but probably whoever has that seat will probably be doing the four-way test going on, since it's closest to read. I know. Just, there's enough people not here who can get caught by this, so. All right, Sergeant at Arms, could you please come up here? I don't think we have a raffle today, but.
Sorry about that. It's great to be back in person here. This COVID thing, I mean, it's affecting so much. All of my clothes, including my belts, shrunk due to COVID. I mean, it's just crazy. Anyway, do we think we'll kind of go to guests? I don't have the guest sheet. If you're guest, raise your hand. Oh, that's right. I have a guest here myself. Just happens to be my son, Greg, who is here helping with get the Facebook streaming going for us. And welcome, Greg. And he's working for free, except for he's getting a meal out of it this time. I usually don't feed him when he does stuff for me. Okay, happy bucks, anyone? Happy, anyone?
thank you, sir. I guess I better throw one in. Last month, Laura and I finished homeschooling our 7-year-old grandson from Virginia Beach. We homeschooled him for about 3 months. And the reason I'm happy is that I finally learned how to do second grade math. So.
And there's another new way that math is done these days, I understand.
I have a happy buck. 3 weeks ago, yesterday I had my right hip replaced, and I'm walking around pretty good and hope to be back up and doing the things I used to be able to do.
More hip than ever. Jeb, are you happy about anything? What's not to be happy? Anyone else? All right. Back to our new president.
Thank you very much, Chuck. Today I have the very proud honor of introducing one of our own as our guest speaker today. Ms. SuAnne Hardee Bryant is a graduate from Virginia Wesleyan College. She attended law school at California Western School of Law. She now currently works for our own Davis Law Group, performing many tasks, including civil litigation, domestic relations, and labor and employment law, which is going to be our topic for today. Of course, SuAnne's most prominent distinction is being a past president of this wonderful Rotary Club. So we've had some new laws come out as of July 1st in the world of employment law. Some very important information SuAnne's going to give us today, whether you're an employer or an employee. So I'll hand it over to SuAnne.
We're going to see how coordinated I am holding a mic and working a mouse. Yep, the mouse is on. Let's see. All right. I started doing labor and employment law fresh out of law school, and I did it almost exclusively for the first 5 years. Then something changed. What changed? Laws changed. Back in those days, if you weren't working for one of the larger law firms, then you were an employee side labor and employment lawyer. And so it's kind of hard to pay the bills. People come to see you who've been laid off their job and want to sue, and they don't have any money. So being a plaintiff's lawyer is a tough way to go. And in '97, when our Supreme Court made some changes to various laws, it kind of shut that down, as you couldn't really be a boutique employment law lawyer unless you were working on the management side. Fast forward many years later, I found myself doing more and more management side work, but focusing on small employers with the idea of keeping them out of court. Well, this year in the General Assembly session, elections have consequences, and boy do they. There was a litany of legislation in labor and employment law like we haven't seen in over 2 decades. And a lot of it passed. Some of it was scary and it didn't pass, but you know it's going to keep getting reintroduced. And so I got the sexy stuff at the end, the stuff people may have been already hearing about, which is interesting. But some of the basics, and it may not affect a lot of you personally, but it affects people you know. But if you're a small business, it will eventually affect you, because it will, anytime the mandatory minimum wages are increased, it affects hiring decisions and things like that. What was going to take effect January 1 has now been rolled back to take effect on May 1. That was the break they gave us for the COVID situation. But Virginia now has a very robust minimum wage act. Before, we did not. We relied on, if you were covered by the federal act, good for you, and if you weren't covered, there was actually no Virginia mandated minimum wage. Most employers are covered, however, by the FLSA. Virginia is now changing that. They have their own wage payment laws, minimum wage act, and the new legislation gets rid of lots of exclusions that used to exist. Let's see if I can switch this over. So here's what's coming down the pike. May 1 of next year, mandatory minimum wage goes to $9.50. As you can see from the chart, it's a sliding scale all the way up to $15 an hour. So yes, we're careening towards the $15 an hour. But if you look at the bottom, those scheduled getting us to $13.50 and then ultimately $15 are not going to become enacted unless they're reenacted. They will not become effective. So there's a little sunsetting provision there, and I guess there's an assumption. So they've kicked the can down the road a little bit. So at a minimum, we know they're going to hit $12 an hour. Unless something changes between now and then. Whether they actually hit 15 requires a reenactment, and that will frankly depend on who's in control of the legislature. Okay. Now, there's a new private right of action. Before, if you weren't getting paid either minimum wages, and that was an FLSA, a federal issue, or if you weren't getting paid on time, wage payment laws, then you basically had an administrative action. You could not go sue in court. Now you can. And importantly, just like under the Fair Labor Standards Act, the federal act, employees can sue individually and collectively, meaning I'm going to sue on behalf of me and all my friends, all my coworkers who say we're not getting paid properly. There are damages, and what I mean by liquidated damages, for those of you who don't know, that is whatever your unpaid wages were, if you were right and you weren't being paid properly, either on time or for a variety of reasons, and then they turn around and double that. That's liquidated damages. You get that. They could even triple the damages. We call those treble damages if the violation is deemed to be willful. So there's things that we advise our employers to do to protect themselves and to have things in the file to show that they sought advice, and that helps mitigate against that. So those are some of the things that you would need to seek some good legal advice on. The kicker is there's also statutory attorney's fees. Attorneys love this, and most business owners like being able to recover their attorney's fees, but in this case, attorney's fees would be awarded against the business owner and in favor of the employee. So that kind of gives an incentive for the plaintiff side attorneys to pursue these cases. Okay. There's a pay stub requirement that actually went in effect January, but it kind of slid under the radar and most people don't know about it. And I guess most people assume if they're using some sort of payroll system or QuickBooks or whatever, that they already did this. There must have been something weird to prompt the legislature to do this, but it's now a written requirement. The following information, I'm not going to read to it unless you can't see, then I can read it out, but you see all the things there listed must be included on a pay stub. There was some question, and it was cleared up later, the number of hours worked in the pay period. Well, what if you're salaried? Your hours aren't normally worked out. They tweaked the law and made it clear that applies if the employee is hourly. So the salaried people, don't worry about that. Another big area that our legislature focused on this past year is worker misclassification. And they saw that there was an issue where businesses were classifying people who are really employees as independent contractors. So therefore, there's no FICA being paid in, all the Social Security, the state tax, the federal tax, none of that was being paid in. There's now a legal presumption that anyone who works for remuneration, so if you're getting paid, you are an employee. And there's some pretty hefty consequences for misclassification. There's also, once again, this private right to sue. So someone who says, yeah, I signed up and I'm getting 1099, and later on determine, wait a minute, I really should be an employee, they can now sue their employer and then get actual damages, compensatory damages, attorney's fees. So the actual damages is what should have been paid into Social Security, Medicare, the tax system, all of that, and once again, the attorney's fees. There's a specific provision about retaliation. There can be no retaliation, and again, that can give a right of action. Something interesting in the contractor world. If you're a prime contractor, you're liable for your subs. So you have to police your subs and regulate your subcontractors because there's now joint and several liability for misclassification. So if you're the general contractor and you hire out the HVAC contractor, you got to make sure your HVAC contractor doesn't have people he's classifying as independents who truly aren't. There's an issue there. And for the contractors, one of the penalties is debarment from future public contracts, that's state government contracts. There's a debarment for a year for the first offense, and then for subsequent years, and then full debarment after that. Okay. Some very broad whistleblower protections that never existed before and now exist. And a lot of employment lawyers think this is an area that can kind of encourages employees sometimes to make the complaints. So again, what is whistleblowing? Well, there's a listing of things what the employee is doing, but what the employers can't do is either discharge, discipline, discriminate against, threaten, that's a broad word, penalize, or retaliate against employees for engaging in certain protected conduct. What's the protected conduct? All right, if someone reports in good faith a violation of federal or state law or regulation to either their supervisor, a government body, or a law enforcement official, if the employee is requested to participate in an investigation, a hearing, or inquiry by a governmental body or law enforcement, if the employee refuses to engage in a criminal act that would result in criminal liability, if the employee refuses to perform an order by the employer that would violate a federal or state law or regulation and informs the employer, I'm not doing this for that reason, if the employee testifies or otherwise provides information to a governmental body, law enforcement, who are conducting investigation, hearing, things like that. There's a 1-year statute of limitations as listed for them to file a civil action. And again, it's the full panoply of remedies that you would see in any typical court proceeding. And of course, the kicker, attorney's fees. So, another big area that we deal with a lot is non-competes. A lot of businesses want to protect their essentially their work product. So they'll do a variety of agreements, non-disclosure agreements, confidentiality agreements. You're not going to disclose trade secrets. And for their certain highly skilled workers in particular, they don't want someone going out, learning the trade and craft, and then going and setting up a competing business. Non-competes have been the subject of lots of litigation and essentially court interpretation. Now we have an actual statute that for what the state calls certain low-income wage earners, they're completely barred. What the state defines as low income is interesting. And I'll click back to that in just a second. I'll go ahead and jump over to that. Whoops, I skipped it. Here it is, $59,124. So if you're paying someone that amount, be less than that amount, that's a low-wage worker. I didn't know that was low wage, but it is. And so I've seen, I know certain industries, all their non-competes from July 1 on are going to be invalid. I've seen it used heavily in the tax prep industry, because I've had people come to me and they're a tax prep person making $35,000 a year, annualized out, if there's work for them throughout the rest of the year, and whether it's one of the big guys, H&R Block or whoever else, they have a non-compete and they have questions about it. That's all prohibited from this point on. So you really need to take a strong look at those. Low-wage earners also include interns, students, apprentices, and trainees, whether they're paid or unpaid, at a trade or occupation in order to gain work or educational experience. So, again, there's a problem. You can't have the non-competes. Independent contractors who are compensated at an hourly rate less than the median hourly wage, which, again, you got to run a formula to figure out what that is. They also are considered low-wage workers, and you could not have a non-compete with them. Now, that's going to be very interesting, because a lot of times when you bring in a truly independent contractor, someone who has their own business, but they're consulting, they're doing something for you, non-competes are quite common. And so you're going to have to look at that wage requirement and make sure you don't run afoul of that, or just bump up the salary over the threshold so you can have the non-compete. And then anyone who works from sales commissions, incentives, and bonuses are actually not low-wage earners, so there's an exemption for your salespeople. All righty. So I think I skipped something. Oops, it's not going backwards. Sorry, here we go. Okay. Back to the non-competes. I want to just make everyone aware there's a posting requirement. Almost with all these new laws, they're giving out the private right of action with the typical civil remedies for back pay, attorney's fees, all the full panoply of damages. But there's also a specific posting requirement that can result in fines to an employer who does not comply. Some of the, there's multiple laws that now have new posting requirements. A lot of times, rather than pay, you get these massive posters in the mail that these agencies want to send to you, and they want to charge you, $100 for a poster, because they know you're trying to figure out what to post and what not to post. Some of these new ones are actually, you print them out on 8.5 by 11 and post them in your workroom, and you'll be okay. You can go to the State Department of Labor and Industry, and the State Department of Labor and Industry has some of those postings that you can then print out and take care of, or you can, someone like me can help you out with that. All righty. And here, you see at the bottom what the $250 for the second offense. First offense, they're going to slap you on the wrist. They're going to fine you. Third offense will be $1,000. So not chump change. All right, we covered low-wage earners. All right, here's the most broad expansions, the expansions that probably cause the most heartburn among a lot of people. And that is the expansion of the Virginia Human Rights Act and the Virginia Values Act. So prior to July 1, Virginia Human Rights Act was a statute that helped some people but really didn't do a whole lot, because what had happened was back in 1997, in response to plaintiffs' lawyers using the Virginia Human Rights Act to say this is the public policy of Virginia, they were using that in what was called a common law claim, so a non-statutory claim for wrongful discharge. General Assembly at that time said, we want to shut the door to that. Or, the litigation's been pouring in, and so if you were a plaintiff, your remedies were pretty limited. If you work for an employer with 15 or more employees, then you came under the federal laws and you could sue under those federal laws. As a practitioner, I can tell you federal court is not a very plaintiff-friendly forum. It's designed to get rid of civil cases on motion and things like what we call summary judgment, and employers know that, so they like federal court and they're not afraid of it. Whereas in state law practice, state court judges rarely dismiss a claim, they let it go to trial. So that plays into strategy and things like that, and how much you're going to have to pay an attorney to defend you. You're going to do a cost-benefit analysis whenever that happens. So Prior to the new changes, it applied to employers of 6 to 14 employees, so those who were not covered. If you had less than 6, there was no coverage at all. And it only applied to discharge. So if the person says, I'm being harassed, there's 6-man outfit, 7-man outfit, and I'm being harassed, there was no remedy because Title VII didn't apply, and the Virginia Human Rights Act only dealt with discharge. And then the discharge only provided up to 12 months back pay, and there was an attorney's fees provision, but it was only 25% of the back pay recovered. So a typical employee earning $45,000 a year could only get that amount. The attorney's only going to get 25% of that, and a lot of attorneys, knowing what it costs to litigate, decided they're just not taking these cases. It's just not worth it. And so you didn't see a whole lot of cases at all, frankly, on this. Well, come the new changes. The Virginia Human Rights Act has now been expanded, and it's very much like the federal Title VII statute. There's a full array of civil remedies and damages. So actual damages, compensatory damages, even punitives, and once again, the attorney's fees model. Those who come under the coverage of the Act has now been broadened. The protected classes, this is where it gets really interesting. Who's considered part of a protected class has been significantly broadened. And then the Act now compensates 15 more things like harassment, adverse employment actions that stop short of discharge for employers in Virginia of 15 or more can be sued under this Act. So the plaintiff doesn't have to go into federal court anymore. They can go into state court, knowing the state court system, and know that more than likely they can get this case to a jury, if the courts ever go back to jury trials in the COVID era, or they're going to get it to a judge. So if you're an employer, that's going to make a significant impact on your decision making, because it's going to cost you a minimum of $50,000, probably $100,000 to defend the case. And plaintiffs' lawyers bank on that, and they're going to say, hey, just throw me 50 or 100 and we'll go away, because you're going to spend that on your lawyer. So it's going to be one of these things where you're going to see a lot more case filings in our state court system. The other thing, and I'll get into this later, is there's this new process for providing reasonable accommodation to any employee experiencing pregnancy, childbirth, or related medical condition. We'll talk about that in a minute. Okay. So, again, it's the 15 or more employees. The coverage now includes employment agencies. It also includes labor organizations, and a lot of the labor organizations were caught off guard by this, because a lot of labor organizations can be an employee themselves. If their president is a full paid time president, or they have an office staff, they're an employee, but they're also a labor organization, and how they handle hiring halls and job referrals also comes under this act, and that's something new. State agencies and bureaus, commissions, all the governmental entities are now covered. School boards are now covered by this, as well as there's a public accommodation, much like in the Title VII statutes. Oh, good, it already flipped it over for me. Okay, we got that. Sorry. Okay. New protected classes. The first one I think is going to result in some interesting litigation, because it's kind of broad and subject to some interpretation. The term "because of race," meaning that an employer cannot discriminate in the terms and conditions of employment because of race or on the basis of race, is now defined to include, and I'll read this because it's interesting, because of or on the basis of traits historically associated with race, including hair texture, hair type, and protective hairstyles such as braids, locks, and twists. What does that mean? Okay, for one, historically associated with race. Is that stereotyping? I mean, what hairstyles are historically associated with race? And I was talking to Jonathan about this, and I'm like, sure, maybe 40, 50 years ago, you would not see dreadlocks on a variety of people. Now you see dreadlocks on a variety of people. It's not just one race wearing dreadlocks. And so I think there's going to be some problems on how this law is interpreted. And I think, it'll probably be, it could be as much as 3 to 5 years before you see the courts work their way through some of this litigation that's going to ensue. because if you have a Caucasian worker who has dreads and you have an African American worker who has dreads, how are they different? So interesting. Virginia beat the feds to the punch, and within, what was it, 2 weeks ago, the U.S. Supreme Court also expanded the definition of sex under the Title VII laws to include sexual orientation and gender identity, but Virginia now has its own laws. So when the law says you cannot discriminate on the basis of sex or gender, that includes sexual orientation, and what the Virginia law defines as a person's actual or perceived heterosexuality, bisexuality, or homosexuality. Perceived, that's again, using a vague word that could subject to judicial interpretation. Gender identity is even more interesting. Gender-related identity, appearance, or other gender-related characteristics of an individual with or without regard to the individual's designated sex at birth. So again, I predict some significant litigation coming out of these changes. Lactation. Evidently, there wasn't enough protection or perceived protections for lactating women, and so they chose to define lactation, which I think most of us know what that means. Veteran status has always been protected under federal law. Evidently, there was no specific protection in our state law, so veteran status is now a protected class that comes under all these protections. Okay, so again, 15 or more employees, you are prohibited from not only discharging, but engaging in any type of adverse employment action, and I gave some of the examples up there. So refusal to hire, failure to hire, lack of promotion, segregating or classifying in ways that adversely affect them. Essentially anything that could be construed as an adverse employment action. And one of the interesting things is all they have to show is that it was a motivating factor. You can have 5 reasons for getting rid of an employee if you're discharging them, or 5 reasons for demoting them. And if the employee can successfully prove that one of the reasons was a prohibited reason, then they're going to be able to recover, despite the 4 other reasons being non-discriminatory. Used to be an analysis was but for the unlawful discrimination, I would not have been fired. Now it's motivating factor analysis. So it's a lot broader and it's a lot easier to sue under. Okay. Once again, the cause of action has now been expanded and it's no holds barred. The employee can sue for just about anything. Modeled after Title VII, there are administrative prerequisites to suit. So the one thing that's going to slow the pace of litigation is, much like under the federal procedure, where everyone heard of the EEOC, Equal Employment Opportunity Commission? If you were trying to file a claim under any of the Title VII or Age Acts, you had to go to the EEOC first and file a suit. It's called a charge of discrimination, and that had to work its way out. I won't bore you with all the details on that. Virginia has now set up something very similar, so there is an administrative prerequisite on that end, with the exception of the pregnancy and childbirth. They exempted that out. So someone claiming discrimination on the basis of childbirth, related medical condition, they can go straight to court without filing the administrative prerequisite. Alrighty. The reasonable accommodation for childbirth, this also has a handbook requirement. I'll get to that in a minute. Employers employing 5 or more employees for each working day in each of the 20 more. So it's a look-back period. I won't bore you with all that. You're required to provide reasonable accommodations to applicants. That's also interesting, not just people, applicants and employees who are experiencing pregnancy, childbirth, or related medical condition, unless doing so would pose an undue hardship. And the burden is on the employer to show that it would be an undue hardship. So what is reasonable accommodation? That could be anything from longer or more bathroom breaks to lactate, express milk, access to a private location other than the bathroom to do it. So lactation rooms or some other private room to do that. Modification of any equipment, allowing the worker to put her feet up, whatever it is. Those are some of the examples. And the requirement is that you must engage with an interactive process, which some of it's common sense. Your employee comes to you and tells you they're pregnant. You probably are going to talk to them, hey, what can we do? What is this looking like? But again, the problem is it opens up potential floodgates to litigation because there's a prohibition on retaliating against an employee who requests the accommodation. So that could be, rather subjective. Oh, I asked to put my feet up and they said no. I'm just giving an example. Again, private right of action, very similar to what we've been talking about. They can go in and sue immediately. And the posting requirement, not only a poster, but an employee handbook provision. I've been doing a lot of that since the middle of June and up till now, revising tons and tons of employee handbooks for our small business clients because they have to have these things in their handbook. And so here's one of them that you must include that information about their right to request the accommodation. Let's see. Okay. There's some other ones I didn't put in here because I knew I'd be flying through this and I wanted to be able to have some time for questions. There is now, I didn't put it in the summary, it's actually found in the criminal code, and Anthony probably, you does criminal law, they've decriminalized small possession of marijuana. The corollary on that is they threw in the same statute that employers can no longer ask employees on job applications, or applicants is a better word, about prior arrest and convictions for simple possession. So you can't even ask about it anymore. It used to be you could ask about any type of crime. There's a prohibition on that now. And then there's also, it came under, I think it was part of what was called the Wage Transparency Act. Not only was that requiring certain things to be on the pay stub, there's another thing that's kind of flown under the radar, and there's now, you cannot discipline, engage in any adverse action, discharge an employee who essentially talks about his wages or his coworkers' wages. Most employers, from a morale standpoint, don't want their employees sitting around talking, hey, I got this bonus, what'd you get? And so most of the time, even though it's common sense that you don't do that, most employers go so far, they put something in their handbook that says you shall not discuss, the terms and compensation, terms of your employment, your compensation, nor shall you, discuss others. Now, just with everything, that's out the window. But there's not a requirement that you post the notice about it. There's not a requirement that you put that in your handbook. And so it's like, okay, it's the law. Don't have something in your handbook that says, I can't prohibit you from doing this. Just stay quiet about it, frankly, if you're the employer, because you don't want to encourage that. So they didn't go so far as to say you must put this in your handbook, because could you imagine that? An employer's handbook, we can't discipline you for asking your coworkers how much they get paid. Yeah, that's just mind-boggling to me. So, and I've done both sides. I've been a plaintiff's lawyer. And I've always taken the mindset, great plaintiff's case comes across my desk, I probably wouldn't refuse it because, hey, money's green. But they're far and few between, and I just, we gravitate more towards helping the small businesses out. So I put a list of 10 things you should do. I've got an 11th. I'll get to that one too. First is you have to update, and not only update, but disseminate to your employees your new policies, particularly your EEO policies. You need to get your handbooks, have a place where you acknowledge the employee signs that they've acknowledged they've received the policies and they understand them, your typical acknowledgement forms, because this is the type of stuff you'll be using to defend yourself later when in potential litigation. You really need to have a very thorough internal complaint procedure that allows the employee to bypass the person they say is giving them grief. So if they claim their supervisor's harassing them, your internal complaint procedure better have a mechanism where they can bypass their supervisor and go to somebody else. You need to review your termination procedures. You need to provide training on what's discrimination and what's not discrimination, particularly with some of the new protected classes, things that may have been joked about in the past or no longer things that can be joked about without potentially getting you in trouble as the employer, if you've got a supervisor or a worker making those type of jokes or improper comments. You need to comply with all the posting requirements. You really need to audit your use of independent contractors and make sure that you don't have people that you're 1099ing who truly aren't independent. The test is if they meet the IRS's 12-point test. Because there's probably 6 different tests depending on which agency you're dealing with for what's an independent contractor. But Virginia, for purposes of these new laws, has defaulted to the 12-point IRS test. One of the foremost being, does this person actually have their own business? Do they have a business license? Things like that. So update your job descriptions, because when it comes to, any question of what the person's doing. And just even without these laws, your job description should be reviewed at least annually. And sometimes that prohibits wage claims as well for people claiming they're doing a job that they're not being properly compensated for. You really need to provide for whistleblower protection. Now that the doors are open for that, you need to have a policy that informs them that they'll be protected for engaging in whistleblowing. Non-competes, I can't emphasize this enough, that's a huge issue. If you have them, look at them. The current ones are okay. It's from July 1 forward. But if you're modifying them and knowing what's going on, you need to take care of all of those. Interestingly, the law says, and I'll get to you in 1 second, you can still have the non-disclosure agreements and the confidentiality agreements. And those are the ones that tend to get upheld anyhow, because the courts have routinely interpreted that as completely reasonable to expect your employees to maintain your confidences and your secrets in the workplace. So that's okay. And then the 10th one was seek experienced legal counsel. You're going to need it. Finally, we'll segue in before I'll take questions. I was asking Janet earlier, and she'll do some research for me later, I'm sure. Look at your insurance policies. Because Janet was telling me a lot of employees companies, when they're signing up for insurance, waive the EPO coverage, the employment practices coverage. You're going to want that coverage. It may be before, if you thought it was too expensive, maybe not. Because one of the first things that happen if people call me and they've gotten sued is show me your insurance policy. Because I'd love to help you, but if you can get insurance defense, you've paid for it. So that's another key. I know Dudley had a question.
Well, I'm going to leave out the observation about you have to be right or wrong. But obviously, I think. But I want to tell you, my eyes, I can't read anything up there.
Right.
Is there a way we can make this available? Send it to us, or-
Yes, I can send it to Roland because it's in PowerPoint format, and he can just either blast it out through email, put it on our members-only page, put it on our internet page, our web page. You can get all of that. Sure, yep, we'll send something out, yes.
I just kind of off the beaten path here a little bit, but can you speak at all to the dangers with respect to the elimination of the state of Virginia being a right-to-work state? I understand there was a lot of pressure for that.
That pressure's not going away. I mean, it didn't make it through this time. I fully expect a push for that come the next legislative session, because the political landscape has completely changed. And so, and for those of you who don't know, right to work, people get right to work and employment at will confused quite often. Employment at will is simply the concept that absent a contract for a specific term of employment, you serve the will or the pleasure of your employer, and you're free to leave and they're free to terminate you at any time, subject to the exceptions for, the discrimination, things like that. Right to work refers to the fact that we don't have closed shops in Virginia. You do not have to join a union if that union is representing the workers in that industry. So for example, the longshoremen, they're probably not in numbers, but in power, you're more bigger, powerful union around here. The steel workers over at Newport News Shipbuilding, there's over 5,000 of them, but it's a weaker union. Not to be disparaging, it just is. But any person can go to Newport News, Huntington Ingalls, they can go to the port and they can get work and they don't have to join a union. Reversing our right to work laws would change that. It would mandate closed shops, which is something quite common up in the north. Whereas if it's a union outfit, in order to get employed there, you have to join the union. And, even, people wonder, what's the incentive behind that? And unfortunately, it's politics, and I don't want to delve into politics too much, but I will say that I predict that's going to be back on the table. There was some leave laws and things that they tried to introduce that was just, I guess, what they say, a bridge too far, even for our legislature. One of them that I'm keeping my eye on is it's modeled after the California statute that would require employers to give time off for an employee to attend their children's school functions. Again, it's, most employers have paid time off policies. You choose your time that you want to take off wisely, but if you start mandating every time someone has to be allowed off, you're not going to have many people left to work, But I predict that one's coming back too. So just you have to keep your eye on it. Yes?
minimum wage law
I'd have to go back and look because most of the time under the FLSA, they're exempt from the minimum wages because that's why a waitress can get paid $4 an hour because she works off tips. I'm pretty sure in that definition of sales commissions that they're exempted, but I could double check that. Yeah. So, and that's the other thing for the state law, since they've modeled so much of this after the federal law, then the question will be, is the federal judicial interpretation of these laws then going to govern? Because what came down this morning, I was reading them as I was coming in, was two brand new U.S. Supreme Court cases. One is dealing with what's called a ministerial exception. And if I've got time, I'll do this. Two Catholic schools had been sued, two different Catholic schools, by former teachers who had been discharged. The schools invoked what's known as the ministerial exception, much like the state can't involve itself in matters of the church. Well, they said this religious school is no different than the church. The state can't involve itself. You can't apply the federal statutes to us because of our church. And the Supreme Court agreed with them. And so there is that exception. So if you work at St. Matthew's or Bishop Sullivan or anything like that, then that employer has a lot more leeway because they need to be able to control and say, wait a minute, this, according to our faith beliefs, we're not subject to these laws. So that's important for those employers to know that. The other one was dealing with the Affordable Care Act and the so-called contraceptive mandate. You know, there had been some legislation about it, but now it came out this morning that it was within the discretion of the regulatory body to regulate that and issue that. So religious and moral objectors to the contraception mandate for health insurance can now not be required to supply that. So that was the other holding. That's employment related I thought I'd tell you about. But I know it's 1:02, but if anyone else has any questions, you can talk to me offline, come see me, and then I'll make sure we get the PowerPoint posted up. Thanks.
Thank you very, very much, SuAnne. Thank you for all the information that you provided us. We are now after time, so if there's any other business for the good of Rotary, speak now or forever hold your peace. All right, we're adjourned.
I'm wondering about the sound. That's the only thing I'm worried about. Yeah, I was thinking about that. Microphone here got far away. Yeah, questions from the audience, I'm not really sure. That's probably not going to happen at all. Well, we could do a separate Bluetooth microphone, maybe. Yeah, we can do whatever equipment we need to make it work. We'll see what happens, and I